a brief introduction. As I said a second ago, I'm James Kipping, Head of Private Client at McIntyre Hudson. Welcome to the second in our series of 3 private client related webinars. I'm joined today by Mike Bell, a private client solicitor from Freeths. I will do a 15-20 minute session to begin with on the tax side of things, focusing on tax planning or IHT planning in connection with wills, trusts, and then Mike will move on to the sort of legal aspects of wills, trusts, and also powers of attorney. Firstly, though, I really should apologise for the issues we encountered last week. I was just telling everyone last Wednesday morning how wonderfully our systems had managed, and we hadn't had any IT downtime. And then come lunchtime, unfortunately, my co-presenter couldn't access the webinar. But hopefully, since then, you've all received our recorded webinar and slides, and you've been able to listen to that at your leisure. We'll send around again a recording of today, along with a copy of the slides that hopefully you can see because I've now shared my screen. If you have questions throughout, there is a button you can press on your toolbar here, Q&A, which will allow you to raise questions during the webinar. What Mike and I have agreed is that we'll do our presentations and then spend probably 10-20 minutes following the end of the talk answering questions on a kind of first come first serve basis. If we don't get through all the questions, one of us will follow up individually afterwards, and of course you're obviously welcome to contact us afterwards anyway. I will flick through. I shan't give you too much or any background about McIntyre Hudson. You know us, and you probably had the 2 or 3 minutes that Patrick gave introducing us last week. So I'll move right on to the detail of the webinar. And the first slide is just about inheritance tax planning generally. It's more of a recap on some of the areas we introduced last week, and an introduction to a couple of things I would like to talk about this afternoon. So just in no particular order, going around the wheel there of ways to reduce your IHT bill. Utilising potentially exempt transfers. That's taking advantage of the 7-year rule. So that's if you give away cash or assets and survive those gifts by 7 years, then the value of those assets or the value of the transfer is outside of your estate and not subject to inheritance tax. Just got to be aware of things like capital gains tax and the gift with reservation of benefit rules to ensure that the gifts are fully effective. Now's a good time to dust off those old life assurance policies just to ensure that they're written into trust. If such policies are written into trust, then the proceeds on death will not form part of your estate. The third one on the wheel there, put gifts into trust for beneficiaries. Well, I'll talk a little about a little bit more in a few moments about the planning opportunities with trusts. Utilising gift and charity exemptions. My colleague Patrick last week discussed the various small gift allowances, so the annual exemption, small gift allowances, etc., and charity exemptions. In particular, I'd reiterate the importance of the gift out of income exemption, which I think is underutilised but particularly valuable. And of course, gifts to charity are exempt from inheritance tax, but if you leave or bequeath at least 10% of your estate in your will to charity, then that actually reduces the rate of inheritance tax from 40% to 36% on the rest of your estate. Utilising any unused nil rate band and residence nil rate bands from a deceased spouse or civil partner. This is just emphasising that if assets transfer from one spouse to the surviving spouse on death, then the survivor can take advantage of the unused nil rate band on their death, as long as their executors make the appropriate claim. And the final one here, before I move on to will planning, is own assets which are not liable to IHT. This is just being aware that certain assets, such as business assets or agricultural assets, might qualify for relief to take them out of inheritance tax entirely, but it's not necessarily just for business owners. The business property relief is available on on certain unquoted investments. So actually, from an investment perspective, you can invest in assets that qualify for inheritance tax reliefs. The last one there is right to will. But of course, I just want to raise a couple of pointers for will planning, aimed mainly at married couples or civil partners. Excuse me. The standard wills for these couples will leave everything to the survivor on the first death, and then to the children or other beneficiaries on the second death. Now, the spouse exemption applies so that no IHT is payable on the first death, and then the survivor benefits from both nil rate bands on the second death, with the surplus being subject to inheritance tax unless a relief or exemption applies. Now, that's all very good, but there are a couple of situations where that position might be improved. So, firstly, on the slide there, couples should consider whether they will benefit from making specific gifts to others on the first death, rather than just leaving everything to the surviving spouse. So that might be because one spouse is a widow or widower from a previous marriage. They may actually be able to take advantage from another further transferable nil rate band, which would otherwise be lost. Or it could also be a good way of ensuring the survivor's estate, as the second spouse to die, qualifies for the residence nil rate band. If you recall, the residence nil rate band is an additional nil rate band, which is abated where the value of an estate before any reliefs exceeds £2 million. So it can sometimes be beneficial to avoid a bunching of assets in the second spouse's estate. Second point on the slide there is where there are business assets that qualify for business property relief, or indeed agricultural assets, it can be advisable to leave them onto a discretionary trust rather than outright to the surviving spouse. The survivor can still be the primary beneficiary of the discretionary trust, so they're not in any way disadvantaged, although it would be advisable for them to have a suitable letter of wishes drafted alongside the trust. And I know Mike's going to discuss this briefly later. But the reason you might leave such assets onto a discretionary trust in your will is that if the business was left outright to the surviving spouse, and it was then sold between the first and second deaths, the proceeds would be in the state of the survivor and wouldn't benefit from business property relief, so would potentially be exposed to inheritance tax at 40%. If instead the business is held within the trust, the proceeds of sale are outside of the survivor's estate, and the IHT exposure is greatly reduced, yet the surviving spouse can still have access to those proceeds should they need it. So that's all I really wanted to talk about from a tax planning perspective in connection with writing your will, but I know Mike will talk a bit more about the legal aspects later in the talk. For the sort of main part of my section of the talk, I just wanted to introduce a few planning opportunities in connection with trust. And this is kind of lifetime planning opportunities. I don't want to go into a lot of detail about the different types of trust, but rather concentrate on these three planning opportunities. There are more, but these are ones we commonly see. So they are, in turn, discretionary trust, typically for grandchildren, but not necessarily. A loan trust, and I'll talk about what that means in due course. And a discounted gift trust, which can actually be really useful because it can provide an immediate discount to your estate for inheritance tax purposes. However, although I don't want to go into a lot of detail, I should explain in simple terms what a trust is. So in principle, it's a simple concept, really. It's the formal transfer of assets, and that could be property, shares, or cash, to a small group of people known as the trustees, with instructions that they hold the assets for the benefit of others, and those others are known as the beneficiaries. So it's the instructions within that trust deed that dictate the nature of the trust. But let's go on to the tax regime, because it's important to understand that most trusts are subject to their own inheritance tax regime, known as the relevant property regime. And this has been the case, since longer than them, but it's been the case that most trusts are subject to this regime since Finance Act 2006 and some quite sweeping changes that came in between that year and 2008. The main exceptions are trusts for disabled or vulnerable persons, certain trusts created in a will which leave assets to bereaved minors, or which provide for an interest in possession to the surviving spouse. Also bare trusts, which I will refer to. Bare trusts really are just an outright gift because the trustees are just holding assets as nominee for beneficiaries. Technically it's a trust, of course, but it's outside of the the relevant property regime. So during this talk, I'll mainly refer to discretionary trusts, which are subject to this regime, and bare trusts, which aren't, because they're like an outright gift. But getting back to the slide that should be on your screen, a discretionary one, rather, sorry, I should explain what a discretionary trust is first. A discretionary trust is where trustees hold and manage assets for a number of potential beneficiaries or classes of beneficiary, but no beneficiary has an absolute right to anything. The trustees have discretion over the application of income and capital of the trust, albeit they may be guided by the wishes of the settlor. Another advantage of a discretionary trust and potentially using classes of beneficiary are that actually you can provide for people that aren't around yet. So again, this is where I talk about grandchildren in particular. A grandparent might provide for their grandchildren in the knowledge actually that they might have further grandchildren that would upon being born become a beneficiary under the trust. But let's get back to the slide. And discretionary trusts are subject to this relevant property inheritance tax regime, and transfers onto such a trust are known as chargeable lifetime transfers for inheritance tax. Now, if the chargeable lifetime transfer amount, that's the gift amount, exceeds the available nil rate band, that's typically £325,000, it can be subject to an immediate inheritance tax charge at 20%. So typically when we're planning, we're trying to avoid this happening. So if we're settling chargeable assets onto a discretionary trust, typically we're trying to keep the transfer of value below the nil rate band amount. If you're transferring assets, so property or shares or what have you, onto a discretionary trust, then that's actually a transfer or a chargeable transfer for capital gains tax purposes. But because there's a charge for inheritance tax, albeit often at 0%, CGT holdover relief is available. So it is possible to transfer assets onto a trust without a CGT charge, and the trustees take on your base cost, if you like, by making that holdover claim. And under the relevant property inheritance tax regime, once the assets are within the trust, exit and periodic, or rather 10-year charges can apply during the lifetime of the trust, but those charges will never be more than 6% of the value of the trust over the available nil rate band. Okay, let's move on to some examples of how trusts are useful in inheritance tax planning. This example here, I'm trying not to confuse you with the slide here, but this is a common piece of planning, and I've called it discretionary trust for grandchildren. But it's not necessarily just for grandchildren. It just works really well as a means of providing income to grandchildren efficiently, because it's not possible for parents to do the same with their minor children. The trust is typically created with either cash or investment of up to £325,000 per settlor to avoid the inheritance tax entry charge that I mentioned a moment ago. Or often we see shares in a family company settled onto such a trust. Typically, the shares of a family company might qualify for business property relief, so their value would not be a significant concern. The settlors in my example here are grandparents, and they would typically also be the trustees, so that they retain control over what happens to the trust fund and how it's managed. The beneficiaries would typically be family, including children, grandchildren, and often to provide a degree of flexibility might include spouses of beneficiaries. Once 7 years has passed, the value of the assets settled are outside of the settlor's estate. So really that's the inheritance tax planning. And actually you could make successive transfers every 7 years to take advantage of a nil rate band in every 7 year period. But at the top of the slide are some points about income tax advantages, which are really, really useful here. So looking at the left-hand side, income arising to a discretionary trust, so that's investment income, on the investments transferred, or perhaps dividend income from the family company, are subject to the highest rates of income tax, which are 45%, and except for dividend income, which is 38.1%. This is known as the rate applicable to trusts, or the RAT, as I've abbreviated in the slide there. However, if the trustees make discretionary income distributions to beneficiaries, then they are paid with a 45% tax credit. So if the beneficiaries themselves are not 45% taxpayers, they can claim a refund for some or all of the tax paid, so that if all the income is distributed, then ultimately the income is taxed at the marginal tax rate of the beneficiaries, which might be rather lower than the settlors if we're talking about family members such as grandchildren with no other income. So overall, it can be much more efficient applying income to family members in this way, rather than, say, the grandparent paying income to their own income to their children or grandchildren out of their taxed income. And actually we see this sort of planning used quite commonly for payment of school fees, for example. Now, on the right-hand side of the slide there, I've introduced the concept of appointing an interest in possession. So although this is a discretionary trust, the process can be made much more efficient if it is possible to appoint what we call an interest in possession over the trust fund. Now, that's a present right to the income as it arises, and in such a situation, the income can be mandated directly to the beneficiary. So, for example, in the case of a trust which holds family company shares, the trustees could appoint an interest in possession over those shares before the company declares a dividend, so that the dividend is paid directly to the beneficiary, or if they are minors, to their guardian. Now, this avoids the administration of the discretionary trust route, with the trust paying the tax and the beneficiary reclaiming it. But it also has the added advantage that the income retains its nature. So rather than being discretionary trust income, as on the left-hand side of the slide here, it would be, if it's dividend income that's payable under the interest in possession, it would retain its nature as dividend income. So actually that would enable the beneficiary to take advantage of, say, their dividend allowance of £2,000. So as everyone has a personal allowance of £12,500 and a dividend allowance of £2,000, it can be possible to pay up to £14,500 to each beneficiary free of income tax from the family company. So you can imagine a situation where there are a number of grandchildren where grandparents are paying for each of their school fees. All of a sudden you can get £14,500 of tax-free income either paid to or applied for the benefit of the beneficiaries, rather than income taxed at the highest rates being used to pay those school fees. Moving on, the next sort of concept I wanted to introduce is that of the loan trust. So in the previous slide, I've highlighted an example of where individuals are able to give up access to capital, but individuals may not be able to give up access to their capital, or may want to do some planning with more than just £325,000 of value, which uses up their nil rate band. So this is where a loan trust can be useful. Now, in simple terms, the individual will loan money to the trustees, either a bare trust or a discretionary trust, and typically funds will be invested in a single premium life assurance bond. Now, with this type of investment, no income arises to the trust, but there will be a cumulative 5% annual allowance, which can be drawn tax-free as a loan repayment, or, in inverted commas, income, while the growth in value of the investment arises outside of your estate for inheritance tax purposes. The life assurance bond is usually used here because income from regular investments can otherwise remain taxable on the settlor under some anti-avoidance rules while the loan is outstanding. In terms of further inheritance tax planning with this structure, obviously the growth in value is outside of the estate here, but the settlors retain access to the capital because it's only been loaned to the trust. But the settlors could do further IHT planning by using loan waivers to utilise their inheritance tax annual exemption, or make larger waivers subject to either the 7-year rule if the investment is held on bare trust, or chargeable lifetime transfer, and again 7-year rule, depending obviously if they use a discretionary trust. And the final concept, which it can be difficult to explain, so bear with me, but it can be really useful part of inheritance tax planning. It's kind of venturing into IFA world a little bit, but it is very much tax planning. So a discounted gift trust. Now, this is a type of trust which also uses a single premium life assurance bond, generally on a joint life second death basis, but where the death benefit is held for the next generation. And again, it can be held on a bare trust or a discretionary trust. But the kind of quirk here is that the settlor retains a lifetime income entitlement from the bond, which is generally no more than the 5% cumulative tax-free allowance. But because they've retained that income entitlement, the value of that income entitlement, which is calculated on an actuarial basis, forms a discount from the initial transfer value and therefore falls out of account immediately for inheritance tax purposes, with the balance falling out of account after 7 years. So rather than run through the points on the slide here, I think it's best illustrated with an example. I apologise for the wordy nature of this slide, but I think it will help get the concept across. And I've used a very, very simple example, and actually I've seen numbers rather larger than this. But nevertheless, this illustrates the concept. So Mrs. Brown is 60 and has an estate of £525,000. There's no transferable nil rate band available and no residence nil rate band. So £200,000 is potentially chargeable to inheritance tax on her death. That's the excess over the nil rate band of £325,000. So the potential inheritance tax bill in this situation is £80,000. Now, Mrs. Brown currently gets payments from her capital, which she relies on. However, she's happy to give away £200,000 as long as she can continue to get payments from it of £10,000 a year. So that's 5% of the 200,000. So she puts £200,000 into an investment bond under a discounted gift trust with quarterly payments to her of £2,500. Her niece and nephew in this case are her beneficiaries. Now, as Mrs. Brown is in good health, the discounted value of her gift is calculated to be £67,531, with the remaining value being the actuarial value of the ongoing right to that income for life. So the remainder of her estate is worth £325,000, as we've set out at the beginning. So only the discounted gift is now liable to inheritance tax if she dies within 7 years. So at 40%, the potential inheritance tax liability is £27,012 instead of the £80,000 it was before. So with that transfer of £200,000, which gives her a right to an income of £10,000 per annum, she also secures an immediate reduction in her estate, or rather inheritance tax exposure, of just under £53,000. Now, Mrs. Brown's quarterly payments continue for the rest of her life, and on her death, the trustees pay out the remaining capital, so in other words, the investment bond and any growth in value taking into account the income payments, to her niece and nephew. And that brings my section to a conclusion, other than to say that we do offer a inheritance tax health check for a fixed fee. So, get in touch with me if you want to talk to me about your inheritance tax position. We can review your estate, calculate your exposure, and identify planning opportunities, all for a fixed fee, which we'll agree with you at that time. So I will now hand over to Mike to talk about the legal aspects of wills, trusts, and powers of attorney.
Thank you, James. Just obviously in the interest of keeping things smooth and free-flowing, and in light of technical difficulties, I've actually sort of pre-recorded my talk. I'm going to try and share now, and perhaps, James, you can just let me know if it doesn't come through. But I will start things going now, and hopefully everyone should be able to hear it. As James has kindly mentioned, I'm a partner in Freeths, a top UK law firm with 13 offices across the UK in all major cities. I myself am based in the London office within the family wealth team, and I specialise in all aspects of estate and inheritance tax planning, to include wills, trusts and powers of attorney. James has kindly covered the various topics involved in the taxes, and I thought it'd be useful to just briefly cover off the basic legal concepts in relation to wills, trusts and filing powers of attorney. Firstly, looking at wills, it is unfortunately a rather common misconception that if you die without a will, your estate automatically passes to your surviving spouse or to your family members. It is in fact the case that if you die without a will, a certain set of archaic principles known as the Intestacy Rules, dating back to 1925, dictate where your assets are to pass if you have died without a will. At this stage, it should be noted that any joint property automatically passes to the survivor. Under UK property law, you are able to own jointly in two different ways. The first is with a joint tenancy, and the second is as tenants in common. A joint tenancy is the most common form of ownership and is probably the way that you hold most of your joint property, joint bank accounts and joint investments, unless you specified to your solicitor at the time that you didn't want to hold in this way. It means that the property automatically passes to the surviving owner, irrespective of what is said in any will or prior agreement. Tenants in common means that each owner has an identifiable share, be that 50-50, 75-25, or perhaps 5 owners each owning 20%. Each owner can then leave their respective share under the terms of their will, rather than it passing to the survivors automatically. If anyone wants any clarification on this or to discuss further, please do leave a comment or alternatively contact me after the webinar. Moving back to the Intestacy Rules, new rules came into place on 6th of February 2020, which all but slightly amended the old provisions. The amendments increased the statutory amount that will pass to a surviving spouse or civil partner to £270,000 plus all personal belongings. If you have children, any remainder above this is then divided into half. One half passes to the survivor outright and the other half passes to the children. Now, as you can see, this may bring a large inheritance tax charge, but also potential for family squabbles. By way of simple illustration, and taking inheritance tax aside, imagine that we have a married couple or civil partnership with spouse X and spouse Y and child Z. There is a joint residential home owned by both parties as joint tenants valued at £500,000. Spouse X also has an investment portfolio of around £600,000 in their sole name. Spouse X passes away and does not have a will. Here, the joint residential property will pass to spouse Y by virtue of the survivorship rules and then being joint tenants. The investment portfolio, however, would need to be split, with spouse Y receiving the first £270,000 and the remaining £330,000 divided equally between spouse Y and child Z. This clearly may not be what the parties wanted and can be avoided by each party simply executing a will. In finishing off with the Intestacy Rules, it should also be noted that if you do not have a spouse or civil partner or any children, the Intestacy Rules still dictate where your estate is to pass. In a nutshell, this is back to your parents, then to your siblings, grandparents, uncles and aunts, and so on, right the way down to finally ending up with the Crown if the estate is left unclaimed. It may well be that you don't want certain members of your extended family to benefit from your estate, and so again, making a will ensure that your estate passes to where you want it to. Next, I thought it might be helpful if I just covered off some of the common terms used in a will, but I don't intend spending much time on these, so again, please do contact me for further explanation. Principally, you have your executors in the will, who are the people that you name to carry out what is said in the will. These are normally the surviving spouse on the first death, then children over the age of 18 on the second death. An executor can, however, be anyone you wish, provided they are over 18. An executor can also be a beneficiary under the will. From a legal point of view, on your death, the executors take control of your assets, and these are held on trust by the executors until such time as they have extracted a grant of probate, which enables them to transfer the titles to the intended beneficiaries. The grant of probate itself is a legal process where the will is confirmed as the last will in existence, and your executors confirm that they are the people named therein. They also confirm to the court that they will do what is said in the will and distribute the estate in accordance with your wishes. Some people like to leave legacies in the will, and for instance, a cash legacy such as £10,000 to friend X or £10,000 to charity Y aren't uncommon, and these gifts are often made free of inheritance tax. Similarly, you may wish to leave certain items such as jewellery, antiques, furniture to specific people. The most common way to do this is to incorporate a clause into the will where you make reference to any handwritten list or memorandum that you may leave amongst your personal papers. I personally prefer this for clients when drafting. It is more personal, but also means that the clients can amend the list as they wish and as their circumstances change. You may, for instance, wish to leave your engagement or wedding ring to your daughter or son, or perhaps certain items of jewellery to your grandchildren as and when they are born. Lastly, the other common term used relates to the remaining estate, or what is often referred to as the residuary estate. This is a term given to the balance of the estate after any legacies, funeral and legal costs and inheritance tax have been paid. The people receiving this are commonly referred to as the residuary beneficiaries, and these will be the surviving spouse or civil partner, your grandchildren, children, or any other named beneficiary. My last point in relation to wills just ties in with the comments that James has made in relation to some tax planning trusts which can be contained in the will, such as business discretionary trusts or trusts for agricultural property. It is quite common for these types of arrangements to have an accompanying letter of wishes. This is a letter written by you to your trustees, advising them as to why you have done something in the will, provides some guidance as to how you want it to be run, and generally gives a little background to your thought process at the time. As the letter is not contained in the will, it is not legally binding. It is also not provable when it comes to probate, which means that it does not become a public document and is merely a letter between you and the executor/trustees. It is therefore down to them whether they wish to share it with the other beneficiaries, depending on the information it contains. Moving briefly now to lifetime trusts. Again, I didn't want to spend too much time on these, as it's more of a tax focus, which James has covered off. But I can, of course, provide more details if you want me to. Now, essentially, trusts spilled out of the Crusades, whereby knights headed off to fight in battle, but wanted to retain the legal title of their lands when they returned. They did, however, want to provide some incentive to the individuals left in charge of the land who were going to farm it. The basic principle has therefore evolved that you can have a legal title, the legal owner, but also an equitable title, which is essentially the value. With this in mind, one of the most common form of estate planning tools is the use of a family trust. As James has alluded to, a trust is a way of giving away an asset to start your 7-year inheritance tax clock ticking. The benefit of using a trust is that you can actually retain control over the asset despite giving it away. For instance, rather than simply giving cash to your children or grandchildren, you could settle the cash into a trust with you as the trustee. You retain the legal control of the asset and can control such things as investment, distribution of both capital and income to the beneficiaries, and also the eventual winding up of the trust. By way of a simple example, one of the things that my firm is seeing a lot of is family trusts being used to advance money to children or grandchildren to purchase a property or to get a deposit on the property, but at the same time retaining control of it in the event of a breakdown in a relationship or other potential claim. A parent or grandparent could settle, for example, £250,000 into a discretionary trust. The trust can then loan this money to the said child or grandchild as either a deposit or to purchase a property outright. The benefit is that the child or grandchild has the property in their own name and can benefit from the ability to live in the property as well as any capital growth. The loan can be secured against the title of the property, and if there is a relationship breakdown, the trustees have the security of a loan against the property and know that it is as protected as it could be in relation to any future proceedings. Trustees could similarly ask for a prenuptial agreement to be signed between any marriage or civil partnership prior to releasing the loan so that the asset is still protected. Once, of course, any relationship or business venture is stable and secure, the trustees have the ability to write off the loan. Finally now moving to powers of attorney, and the correct name of the new documents as of 2007 are lasting powers of attorney, or LPA as it's sometimes shortened to. This is a document that you put in place now in the event that you are incapable of managing your personal affairs or decisions over health and welfare. Obviously, the more common necessity for the LPA is old age and the onset of dementia or Alzheimer's. However, the sad and more recent accident of Michael Schumacher highlights the fact that it is important for everyone to have LPAs in place if they are no longer capable of managing their affairs. LPAs are documents that you sign now, appointing your chosen attorneys, and then you register them with the court and put them away alongside your will. The hope is that they are never needed, but they are important insurance policies should the need ever arise. It should be noted that if you ever become mentally incapable of managing your affairs and you do not have an LPA in place, banks and financial institutions are under a duty to freeze any sole and also joint accounts to protect you. This means that your surviving spouse or civil partner may suddenly be limited in their own activities because the account is frozen. Many banks and financial institutions have taken it upon themselves to do this to avoid them being blamed for any wrongdoing on the account. It is also important to point out that if you do not have an LPA in place and you lose mental capacity, then you are not able to sign one at that stage because you lack the mental capacity to understand the document you are signing and the powers that you are giving away. The alternative, unfortunately, is a rather lengthy and expensive process known as a deputyship order. This is where one member of the family has to make an application to the court to be named as your deputy to manage your affairs. This process can take anywhere between 3 and 6 months and cost substantially more than a power of attorney would. The deputy also then has to seek the court's permission for any major dealings, such as the sale of a house or liquidation of an investment portfolio, and must also submit to the court an annual account which needs to be approved and an appropriate fee paid. It's therefore quick to see that a power of attorney is a very important document to put in place, especially when considering alongside wills and estate planning. There are 2 types of power of attorney, one relating to property and financial affairs and the other relating to health and welfare decisions. You're able to sign just one of each, or alternatively you can sign both. You can name up to 4 primary attorneys who can act jointly or jointly and severally, i.e. one of them signing a cheque rather than all of them having to. You can then name up to 4 reserve attorneys in the instance that all the primary attorneys are unable to act or have passed away. Whilst it is not common, you can offer guidance or restrictions in each document as to how you would like the attorneys to act. You could, for instance, only give your attorney the power to operate one bank account, or alternatively prevent your attorney from selling your main residential property. The Property and Financial Affairs LPA covers all decisions relating to your financial assets as well as your property in the UK. The Health and Welfare LPA covers all decisions relating to matters of care, health and social welfare, such as decisions as to any care home, right down to decisions as to who has the ultimate say in relation to life-sustaining treatment. I do hope that the brief run-through of all of the above has been interesting, and of course, if anyone has any questions, please do raise them in the comments section, and we'll try to address them if we have time. Alternatively, please contact me directly using the details on the screen.
Cool. Thank you, Mike. I hope everyone's found that useful. I don't think there are any outstanding questions, but if anyone wants to submit a question, we'll hang on for a few minutes now. I can, we'll disappear as the participants drop off. But I'd just like to say that we have the third in the series, lined up for 2 weeks today. That is again a joint webinar with Freeths, but this time focusing on buy-to-let property matters. So from a legal perspective, we'll be looking at landlords' rights, and from a tax perspective, I will point out a few planning opportunities and also cover the new capital gains tax rules, which now require the disposal of residential property to be reported to HMRC with the tax paid within 30 days. So please sign up. I'm sure the invites will come round again, but you can sign up via our website. And as I say, if anyone's got any more questions, then do write them down. And in actual fact, I can see a couple have just popped up. So the first one, Manpreet asks, can you gift property and put it into a trust? Yes, you can transfer assets as well as cash into a trust. In relation to property, one of the key considerations will be the value of that property and whether that creates a chargeable lifetime transfer in excess of the nil rate band. Also need to be aware of the gift with reservation rules. So if you gift a property into a trust, the settlor shouldn't be able to continue benefiting from that property. Otherwise, the gift is ineffective for inheritance tax. But yes, in principle, you can gift a property and put it into a trust. And this might be one for Mike, but Tom Penman asks, who has to agree a deed of variation if there is no will? So can I ask Mike to deal with that?
Yeah, sure. Thank you, Tom. Essentially, it would who would be inheriting under the Intestacy Rules. So if there's a surviving spouse, children, ultimately it is down to them. But importantly, if the children are under the age of 18, then they can't actually be signing away deeds to vary their entitlement. So ultimately, it would have to go to court then to make an application, which will cost a lot of money. There is no guaranteed chance of success on whether the court will agree it. So it's sort of an open-ended question, really, as to whether the variation, if there is an intestacy and there are minor children, would be allowable. And ultimately, of course, it can be fixed fairly straightforwardly by executing a will during your lifetime to avoid the intestacy rules kicking in. Just following on from that as well, you can vary a will after someone has died, and again that needs to be agreed by the executors and also the people that would be inheriting under the will.
Thanks, Mike. Hopefully that answers the question. Someone also asked for a copy of the slides. Just to confirm, we will send around probably tomorrow a recording of the webinar and the link to the slides, and obviously our details will be on there, so you're obviously welcome to contact us with any questions. Sorry,
I did see on there. I know I answered it while you were talking, but a question from Abra, who asked if there is a will in place, then is the distribution to any beneficiary free from IHT from the deceased estate? I think that was the first question in, so I thought I'd just cover that one off quickly. And in answer to that, no, unfortunately not. Just because you have a will, it doesn't mean that a distribution is free of inheritance tax. Clearly, if it's you're leaving everything to your surviving spouse, then that should qualify, subject to domicile. I won't go into that now, but that should qualify for the spouse exemption and therefore be free of inheritance tax. But on second death, or if you are leaving to anyone who is a non-exempt beneficiary, i.e. not a spouse or a charity, then after the using up of your nil rate allowance, the rest will be subject to IHT of 40%.
Okay, thanks, Mike. Ramsey Hakim asks, for lifetime gifts, does the 7-year rule start on the date of the gift, or is it linked to the tax year when the gift is made? It's on the date of the gift, Ramsey, and I've had a couple of situations where people have died either the right side or the wrong side of the 7-year date, unfortunately or fortunately. Adrian Buckley asks, non-residency, owner of a UK company and personal property, in brackets 400k. The company is owned by a Spanish family company. How do I stand? Well, your interest in that UK company then is an indirect interest via the Spanish company. So your asset is the shares in the Spanish company. Now, your residency position probably doesn't affect your inheritance tax exposure, because inheritance tax exposure is governed primarily by your domicile. So if you are UK domiciled or of UK domicile, then the value of the Spanish company shares will be within your estate and potentially subject to inheritance tax, subject to reliefs, etc. If you are non-UK domiciled, then the Spanish company shares are non-UK situated assets. So by first principle is that that's not within the charge to inheritance tax, but just be aware of what we call the IHT anti-enveloping rules that came in from April 2017. So where the corporate structure here owns UK residential property, then that could still be subject to, or rather your interest in that structure could still be subject to UK inheritance tax. Hopefully that answers the question. But Adrian, I know you, so you can give me a ring if you want to talk through that any more. And Jennifer King asks via the chat, do holiday homes run as a business fall outside of business property relief, so the value is within the estate? That's the first question. So, right, this is an awkward one actually, because the relatively recent cases on this, and obviously HMRC's view is that generally speaking, holiday homes, even though they might be holiday lets that qualify for other tax reliefs, generally don't qualify for business property relief on the grounds that really the income derived is rental income, and rental income is investment income, and therefore excluded from business property relief. There are a couple of cases on this. The Pawson case back in, I think, 2013 kind of confirmed that that is HMRC's and the court's view, generally speaking. There was an interesting case of a bed and breakfast or holiday let a year or so ago, where actually the taxpayer won and got business property relief on their business, and that was really down to the level of additional services provided. I can't recall the exact nature, but it was quite unusual, the amount of services provided in addition to the letting of a room or a property. If you want to talk about your particular situation, then do get in touch and I'll be happy to provide more information. I don't know if Mike's got anything to add to that.
No, I think covered well there, James. Yeah.
Second question here, I think this is the last one, unless I've missed one. No, there is another one, sorry. But anyway, this is the next one. Please repeat what you said about giving a percentage of your estate to charity and thereby reducing the value of your estate by or your IHT by 10%. If in your will you give 10% or more of your estate to charity, then the rate of inheritance tax on the rest of your estate is reduced from 40% to 36%. Is that a fair summary, Mike?
Yeah. Yes. Yeah.
Again,
by making the gifts in the, and obviously it has to be to sort of registered charities, sort of charities registered with the Charity Commission, or in sort of extreme circumstances, someone who is doing charitable, noteworthy causes, things like that.
Yeah, great. On the basis that's kind of a relation to will writing and how your will might be drafted. Perhaps if you've got questions on that, Jennifer, contact Mike rather than myself. Couple of other questions come in. Paul Guzzi asks, what are your views on whole life second death insurance policies put into trust for IHT planning? So this is presumably referring back to what I was saying about discounted gift trust planning. But correct me if I'm wrong, or give me a ring afterwards. My view are that the opportunities for tax planning are, in the right circumstances, are really very good. And this is accepted planning. It's been around for a long time, certainly way before my time. And HMRC set out in their guidance their acceptance to such planning. So on that basis, my view is for the right people, it's excellent planning. You got anything to say there, Mike?
Sorry, I was just going to say, Paul, as well. I think if you're talking about sort of life insurance against inheritance tax and individuals sort of paying premiums during their lifetime, then I certainly am finding that it's a very common way of planning for the inheritance tax. Obviously, it's not kind of mitigating or avoiding the inheritance tax. It's the individuals now paying premiums during their lifetime to for an insurance policy to pay out on the second death, and that policy is then used by the beneficiaries to settle the inheritance tax. But certainly there was a period where that has sort of dropped away, but over the last 2 or 3 years, it's sort of come back with a vengeance, and is a very popular method of planning for inheritance tax. You know your monthly or annual premiums, you know the payout, and you can increase those or reduce those as and when your circumstances change. If there is any sort of balance left over after payment of inheritance tax, then that sits outside the estate and passes to your beneficiaries.
Thanks, Mike. Sorry, Paul, that's the correct answer. I misread your question. Although what I said is equally valid, I suppose, if the question was different. Ray Lewin asks, what compliance with the registration of trusts are raised when one is created on death? From memory, Mike, and perhaps you can correct me if I'm wrong again here, those trusts have the same registration requirements as any lifetime trust, in that they are registrable under the Trust Registration Service as and when there is a tax consequence.
Yes, yeah. I mean, yeah, it obviously all depends on what sort of trust you're talking about, but certainly discretionary trusts are. Life interest trusts, not so much, depending on what the assets are.
Am I right in saying that actually that those rules are going to be extended to all trusts under a European regulation?
I believe so, yes.
Yeah.
When it will happen, I don't know. There's been talk of it for a while.
It's only going to become more onerous, I think, isn't it?
I was going to say, yeah, it's as the world signs up to various disclosure agreements and sort of registers of beneficial owners and trusts and offshore companies, it's only going to go one way.
Yeah, I agree. And that's it in terms of questions. I can see a few people dropping off, so we've probably come to the end. I'll just repeat that obviously contact Mike or myself directly if you've got any questions, and we'll send around slides and a copy of the recording of today's webinar probably sometime tomorrow. So thanks all for listening, and hope you have a good afternoon.
Thank you all.